Are you wondering if the judge is going to take into consideration the maturity level of your child or your child's emotional needs and not just the needs of each of the parents in your child custody case? My name is Patrick Slaughter, and the answer to that question is yes. Tennessee Code Annotated Section 36-6-106 has one of the best interest factors that judges has to consider as the emotional needs and development level of the child. That's number 7. So a judge is obligated to look at what are the emotional needs of the child in such a custody determination. Now, what does that mean? Well, sometimes children may have certain attachments to one parent or the other that may be good or may not be good. And a judge has to look at that and consider, is that relationship and that condition something that should be fostered or nurtured? Is the child engaged in some kind of activity that requires one parent to be more engaged or more involved than another, perhaps? We see this a lot when young ladies, when young girls are reaching puberty. Sometimes they need a little extra help from their mother. And Lord knows us fathers aren't as good as we would hope to be sometimes. That's a generalist statement. That's not to say all fathers are bad at that. But that is something that is quite often brought to bear in a custody case. Same thing with young men. Sometimes young men are coming up in their teenage years, and fathers want to have a more earnest relationship with the young man, with the belief that they're better able to help the child to mature into being an adult male. I don't know that a lot of those hold as much weight for judges as we think they are. I think they're more involved in cases where maybe you have a special needs child who has been primarily with one parent. Then the developmental need of that child is probably going to require that person remain their primary caregiver, unless for some reason that person has become unfit or something's happened to render the relationship not beneficial for the child. I think you see this again in situations where maybe children have had certain emotional problems, and we're looking to see which parent is best able to help the child overcome what emotional problem they're dealing with. That's fairly frequent. So you want to look at those and see, what kind of emotional need does my child have? Does my child have any particular behavior, any particular need that is better met by one parent than the other? And if you believe that, then you need to be able to describe why you believe that. And more importantly, you need to be able to offer some form of evidence or testimony that can bolster that claim. It's not going to be enough just to go in and say, I think my child needs me more because, it's a little girl and I'm a mother and I believe this. Or I'm a dad and I think I need to be able to teach my kid how to go hunting and how to be a man. I don't know that those are going to go as far with the judge. It might. But I think mostly judges are going to look for evidence where children have certain emotional problems or emotional needs, and they're going to look to the parent that's best able to help a child overcome those circumstances to be the primary parent in that child's life. I think that's really where this best interest factor really comes into play. And it's complicated. Not every attorney gets it. Sometimes in situations I'm in, I will look for therapist records and things of that sort. But if you find yourself in this quandary and you're trying to decide if this is something that you need to look into further, feel free to pick up the phone, give me a call. I'm happy to listen to the circumstance and maybe give you my opinion or give you some ideas of where you might seek further assistance or further kinds of documentation to get the help that the child might need. In the meantime, obviously, if your child has a need, address the need, and everything flows from that. If you believe your child has an emotional problem, help that child overcome that problem, and along the way make sure that you document that and be prepared to present evidence on that issue if you find yourself in a child custody trial.